Document Part 1, 1400 words. The courtroom was quiet, too quiet. Not the kind of silence that feels peaceful, but the kind that presses down on your chest like a heavy blanket. Fluorescent lights hummed overhead, casting a pale glow on worn wooden benches and scuffed tile floors. A few people sat scattered in the gallery, mostly reporters waiting for something to happen, a couple of curious locals, and one anxious woman twisting a tissue in her hands. She kept glancing at the side door where defendants usually entered. Then it opened. A teenager stepped in, shoulders hunched, hands tucked into the pockets of a faded hoodie. He looked like any kid you might see waiting for the bus after school, except for the way his eyes scanned the room, sharp and steady, like he was taking everything in. He didn't shuffle or fidget. He just walked calm and deliberate until he stood before the bench. The judge sat up straighter. She'd seen hundreds of kids in her courtroom over the years, some scared, some angry, some completely checked out. But this one, there was something different about him. Not cocky, not nervous, just present, like he belonged there even though he clearly didn't. "State your name for the record," she said, her voice firm but not unkind. The teen gave a small nod. "I'd prefer not to, Your Honor." A murmur rippled through the room. Even the bailiff raised an eyebrow. Refusing to give your name in court wasn't unheard of, but it was unusual, especially for someone so young. The judge narrowed her eyes slightly. "You understand you're required to identify yourself?" "I do," he replied. "But I also understand my rights, and right now I'm choosing to remain anonymous until certain facts are clarified." Now the judge leaned forward. This wasn't just odd, it was borderline defiant. She glanced at the file in front of her. The charges were minor: trespassing on private property and causing a disturbance. According to the police report, he'd been found late at night near a closed law office downtown shouting about legal injustice and refusing to leave. The officers assumed he was just another frustrated kid acting out. They cuffed him, ran his ID, and booked him without much thought, but standing here now, he didn't look like someone who'd lost control. If anything, he looked focused. "Let me be clear," the judge said, her tone sharpening. "This isn't a debate club. You're in a court of law. You've been charged with a crime. If you don't cooperate, I can hold you in contempt." The teen didn't flinch. Instead, he took a slow breath and said, "With all due respect, Your Honor, contempt requires willful disobedience. What I'm doing isn't defiance, it's due process." That stopped her cold. The public defender assigned to the case, a tired-looking man who'd already been through 3 hearings that morning, blinked in surprise. He hadn't even spoken to the kid yet. He certainly hadn't prepped him to quote legal doctrine. The prosecutor, a young woman with a neat bun and a stack of folders, shifted in her seat. She hadn't expected a fight either. This was supposed to be a quick plea deal, maybe community service, a warning, and everyone goes home, but the teen wasn't playing along. "I'd like to address the charges directly," he continued, his voice calm but clear enough to carry through the room. "The accusation is trespassing. But under Section 142 of the State Penal Code, lawful presence on private property includes situations where a person reasonably believes entry is necessary to prevent harm or expose wrongdoing." He paused, letting that sink in. "The building I was near houses a law firm that recently dropped representation for 5 low-income clients without notice, clients who were days away from eviction hearings. I was attempting to deliver evidence of that breach of professional conduct. I never entered the building. I stood on the public sidewalk, and I only raised my voice after being ignored for over an hour." Now the courtroom was completely still. Even the clock on the wall seemed to tick louder. The judge stared at him. "Are you saying you're not just some kid who wandered onto private property?" "I'm saying the facts don't support the charges," he replied. "And if we're going to talk about disturbances, maybe we should also talk about the real disturbance, the one where people lose their homes because their lawyers vanish without a trace." A few people in the gallery exchanged glances. One reporter quietly opened a notebook. The judge exhaled slowly. She'd been on the bench long enough to know when someone was bluffing and when they weren't. This wasn't rehearsed. It wasn't dramatic. It was precise. Too precise for a high school student with no legal training. "Who taught you that?" she asked, her voice quieter now. "No one taught me," he said. "I studied it." "Studied it where?" He hesitated just for a second. Then he said, "At law school." The room seemed to hold its breath. The public defender nearly dropped his coffee. The prosecutor's pen froze mid-note. Even the bailiff stopped pretending to look bored. The judge leaned back, her expression unreadable. "You're telling me you're a law student?" "I graduated last spring," he said simply. "I passed the bar in July," then disbelief. Then confusion. Then a wave of murmurs that the judge quickly shut down with a sharp rap of her gavel. "Enough," she said. Counsel approached the bench. The prosecutor and public defender both stood, but the teen stayed where he was. He didn't look smug. He didn't look proud. He just looked tired, like someone who'd been carrying a secret too long. As the lawyers huddled with the judge, whispers filled the gallery. Was this real? Was he lying? Could someone that young really be a licensed attorney? Back at the bench, the judge's voice was low but intense. "If what he's saying is true, this changes everything. But if he's fabricating credentials, that's a felony." The prosecutor nodded. "I'll verify his bar status immediately." The public defender just shook his head. "I've never seen anything like this." Minutes later, the prosecutor returned with her phone. Her face was pale. "He's listed. Active license. Passed the bar on his first try. Top 5%. The judge closed her eyes for a moment, then opened them and looked directly at the teen. "Why?" she asked. "Why come in here pretending to be a defendant?" He met her gaze without flinching. "Because no one listens to lawyers. But everyone watches how the system treats a kid in a hoodie." She didn't respond right away. She just studied him. The calm posture, the clear eyes, the quiet confidence that had nothing to do with arrogance and everything to do with knowing exactly what he was doing. Finally, she spoke to the room. "The charges are dismissed. But this isn't over." And with that, the teen gave a small, respectful nod, then turned and walked out the same way he'd come in. No fanfare, no victory speech. Just a young man in a hoodie disappearing into the hallway, leaving behind a courtroom full of people who would never see the justice system the same way again. Outside, the sun was just breaking through the clouds. He didn't look back. He had more work to do. The courthouse steps were still damp from an early morning rain when he walked out, hands in his pockets, hood pulled low. People inside were buzzing, reporters scrambling for quotes, court staff whispering in corners, even the security guards glancing his way with new eyes. But outside, the world kept moving like nothing had happened. Cars honked. A street vendor flipped burgers on a grill. A bus rumbled past, full of people who had no idea a courtroom had just been turned upside down by someone who looked like he should be in homeroom, not arguing case law. He didn't stop, didn't smile, didn't check his phone. He just kept walking, head down, until he reached a quiet bench in a nearby park. Only then did he sit, shoulders finally dropping like he could breathe again. What he'd done was risky, maybe even reckless, but necessary. Back inside the courthouse, the judge sat alone in her chambers, staring at the empty file on her desk. The charges had been dropped, yes, but the questions were just beginning. Who was this kid, really? Why go undercover? And more importantly, was he telling the whole truth? She picked up the phone and called the State Bar Association. "I need verification on a license," she said. "And I need to know if there's been any disciplinary action." Meanwhile, downtown, a local news station had already posted a short clip online. "Teen stuns courtroom, claims to be licensed attorney." Within an hour, it had thousands of views. Comments poured in, some calling it a hoax, others calling it inspiring. One said, "If he's real, he just exposed how we treat kids who look like him." Another replied, "Or he's just playing dress-up with the justice system." But the truth was far stranger than either guess. 2 days later, he returned to the same courthouse, not in a hoodie this time, but in a simple button-down shirt and slacks, still young-faced but now impossible to ignore. He wasn't there as a defendant. He was there to file a formal motion, a request to reopen 3 closed juvenile cases that had been dismissed without proper legal counsel. All 3 involved teens from the same neighborhood he'd pretended to be from. All 3 had ended with probation, fines, or worse, based on rushed hearings and zero defense. The clerk behind the counter recognized him immediately. "You're the kid from last week." "I'm not a kid," he said gently. "I'm an attorney." She blinked, then nodded slowly and accepted the paperwork. Word spread fast. By noon, the prosecutor's office had received a copy. The public defender's office was in an emergency meeting. And the judge? She called him into her chambers before the end of the day. This time there were no gavels, no gallery, no performance. Just two people in a quiet room, sunlight slanting through the blinds. Why those 3 cases? She asked, getting straight to the point. Because they're the tip of the iceberg, he said. In each one, the defendant was never told they had the right to request a continuance. They weren't offered interpreters, even though 2 of them barely spoke English. And none of them had anyone explain what probation really meant. Not the fines, not the check-ins, not how one missed appointment could land them in detention. He leaned forward slightly. I sat in on those hearings myself, weeks ago before anyone knew who I was. I watched kids nod along like they understood when really they were just scared and trying to get it over with. The judge didn't interrupt. She'd seen it too. The system moving so fast it left people behind. But she'd always told herself it was the best they could do with limited resources. Now someone was holding up a mirror. How did you even get into law school so young? She finally asked. He gave a small shrug. I skipped a couple grades. Read everything I could get my hands on. Worked nights to pay for prep courses. Took the LSAT at 16. Law school wasn't easy, but being ignored was harder. There was no bitterness in his voice. Just honesty. She studied him for a long moment. You could have just written a paper. Filed a complaint. Joined a reform group. I tried, he said. No one listened. Papers get filed and forgotten. Complaints disappear into bureaucracy. But if you show up as the problem, become the problem, suddenly everyone pays attention. She let out a quiet breath. That's dangerous, I know, he said. But so is doing nothing. The next morning, he stood in front of a community center, not a courtroom. A dozen teenagers sat in folding chairs, some skeptical, some curious. He wasn't there to impress them. He was there to listen. I used to sit where you are, he told them. People saw my age, my clothes, my neighborhood, and assumed I wasn't smart enough, serious enough, worth enough. But your voice matters, even if the system acts like it doesn't. One teen raised a hand. Did you really pretend to be arrested just to prove a point? Not just to prove a point, he said. To change the point. The system isn't broken because of one bad judge or one lazy lawyer. It's broken because we've accepted that some people get less justice than others, and we look away. Later that day, a retired law professor reached out. He'd seen the news clip and recognized something familiar. The way the young man cited precedent, the rhythm of his arguments. He dug through old bar exam records and found it. A near-perfect score, a thesis on juvenile legal access, and a recommendation letter from a federal judge who called him the most principled legal mind I've encountered in 20 years. The professor called the local paper. This isn't a stunt, he said. This is someone who's been preparing for this moment his whole life. Back at the courthouse, the judge reviewed the 3 cases he'd flagged. She reread the transcripts, watched the grainy courtroom videos, and for the first time in years she felt a knot of shame in her stomach. Not because she'd done anything illegal, but because she'd accepted good enough when it wasn't good enough at all. She issued an order. All 3 cases would be reopened. New hearings, full legal representation. No shortcuts. When the news broke, it didn't go viral, but it rippled. Through legal aid offices, through youth centers, through late-night conversations in apartment kitchens where parents whispered, maybe things can change. He didn't give interviews, didn't post selfies with his law license. He just kept showing up, sometimes in court, sometimes in community meetings, sometimes just walking the same streets where he'd once pretended to be lost, because the disguise was off now. But the mission wasn't over. And somewhere in another courtroom, another kid was about to stand before a judge, maybe scared, maybe silent. And this time, someone might actually see them. Not just their age, not just their clothes, but their right to be heard. That was the real victory. Not the headlines, not the shock, but the quiet, stubborn belief that justice shouldn't depend on how old you look or what you're wearing. And for the first time in a long time, that belief had a face, even if it was younger than most expected. It started with a backpack, not a briefcase, not a leather satchel with legal pads and a fancy pen, just a worn-out backpack, the kind you'd see slung over a high schooler's shoulder after football practice. Inside were notebooks filled with cramped handwriting, printouts of court transcripts, and a dog-eared copy of the state's criminal procedure code. Tucked in the front pocket, a bus pass and a half-eaten granola bar. Nothing about it screamed lawyer. But that was the point. Weeks before he ever stepped into that courtroom as a defendant, he'd spent his days riding city buses, hanging out near rec centers, and sitting in on juvenile hearings not as counsel, but as a kid in the back row with a notebook hidden under his hoodie. He wasn't just studying the law. He was studying how the law felt to those on the receiving end. Most people think justice is about rules and rulings, but he'd learned early that it's also about tone, timing, and who gets believed without having to prove themselves. And in too many courtrooms, kids who looked like him, wearing hoodies, speaking softly, avoiding eye contact out of respect, not guilt, were already behind before they even opened their mouths. So he made a decision. If no one would listen to a lawyer, maybe they'd pay attention to a troubled teen. He didn't fake his age. He didn't lie about his background. He just disappeared into the role, cut his hair short, bought second-hand clothes from a thrift store, practiced slouching his shoulders just enough to look unsure. He even let his voice crack a little on purpose, not to deceive, but to mirror the nervous energy he'd seen in real kids facing judges alone. His plan wasn't to embarrass anyone. It was to gather proof, real, undeniable proof, that the system treated young people differently based on how they looked, not what they'd done. One afternoon, he sat in a different courthouse, watching a 16-year-old get sentenced to 6 months in juvenile detention for missing 3 probation check-ins. The kid hadn't run away. He'd been working nights to help his mom pay rent after his dad got sick. But no one asked. No one checked. The judge just sighed, said, "Another one," and signed the order. That night he wrote in his journal, "We don't fail kids because the law is broken. We fail them because we stop seeing them as people." He'd already passed the bar by then. Had offers from firms in the city, even a clerkship with a federal judge. But he turned them all down. Not out of pride, but purpose. He knew he could win cases in a suit and tie, but he wanted to fix the part of the system that never even gave kids a real chance to have a case in the first place. So he went deeper. He volunteered at a youth shelter under a fake name, listening to stories over lukewarm soup and donated socks. He heard about kids signing plea deals they didn't understand because the public defender had 30 other cases that day. He heard about teens getting labeled repeat offenders for things like loitering or curfew violations, charges that would have been warnings in wealthier neighborhoods. He took notes. Not just facts, but feelings. The shame in a mother's voice when she said she couldn't afford a lawyer. The quiet anger in a teen's eyes when he was told, "You'll thank me later," after being sentenced without a word in his own defense. All of it went into his plan. The night before his arrest, he stayed up late reviewing the law office he'd target. Not randomly, he chose it because it had a history of taking on low-income clients, then quietly dropping them when their cases got complicated. He'd collected emails, voicemails, even a signed retainer agreement from a family who'd been ghosted days before their eviction hearing. He wasn't trespassing. He was delivering evidence on foot because certified mail had been ignored twice. When the police showed up, he didn't resist. He answered their questions politely, gave his real ID. But when they booked him as a juvenile delinquent, he didn't correct them. Not yet. He wanted to see what happened next, and what happened next was exactly what he feared. At intake, no one asked if he had a lawyer. No one offered him a phone call beyond the standard script. He was fingerprinted, photographed, and placed in a holding cell with 2 other teens, one crying quietly, the other staring at the wall like he'd been there before. The whole process took less than an hour, efficient, cold, routine. That's when he knew he had to speak up in court, not just for himself, but for everyone who'd sat in that cell and stayed silent because they didn't know they had a voice. Back in the present, after the courtroom reveal, reporters started digging. They found his graduation photo, standing alone in an empty auditorium because he'd finished his degree early during summer session. They found his bar exam results verified by the state. They even tracked down his old landlord, who remembered a quiet young man who paid rent on time and studied until 2 a.m., surrounded by law books and instant noodles. But the real story wasn't in the facts. It was in the why. At a small coffee shop near the courthouse, he finally agreed to talk off the record with a veteran journalist who'd covered the courts for 30 years. No cameras. No headlines. Just 2 people over black coffee. "Why go through all this?" she asked. "You could have filed a complaint, started a nonprofit, Written a book. He stirred his coffee slowly. Because reports don't change how a bailiff looks at a kid. Policies don't stop a judge from assuming guilt before hearing the facts. I needed to show what it feels like to be invisible in your own defense. She nodded. She'd seen it too. The subtle shifts, the quick judgments. The way some defendants got patience and others got impatience based on nothing but appearance. You took a huge risk, she said. I know, he replied. But the bigger risk is pretending the system works fine when it's leaving people behind every single day. Later that week, a group of public defenders met in a conference room, not to defend their workload but to ask, how do we do better? One of them admitted, I've rushed through hearings, not because I didn't care but because I had no choice. Another said, maybe we need to slow down, even if it means fewer cases. That was the ripple he'd hoped for, not fame, not revenge but reflection, and in a quiet apartment on the edge of town, a teenager watched the news clip of the courtroom moment for the 10th time. He'd been in that same courthouse last year, got probation for something he didn't do, just because he was too scared to speak up. Now seeing someone who looked like him stand tall and be heard, it planted a seed. Maybe he wasn't powerless, maybe the system could change, not overnight. Not with one person, but with enough voices, especially the ones we've been taught to ignore. And somewhere, a young man in a plain shirt and worn shoes kept walking. Not toward the spotlight, but toward the next kid who needed to know. You matter. Your story matters, and you don't have to wear a suit to deserve justice. The morning after the courtroom reveal, the State Bar Association opened an official inquiry. Not because they doubted his license, that had already been confirmed, but because what he'd done sat in a gray area no one had really tested before. Going undercover as a defendant? Pretending to be someone you're not in a legal proceeding? It wasn't illegal exactly, but it wasn't exactly encouraged either. He got a call early that day. Calm voice on the other end. We need you to come in. Bring your notes. Bring your reasons. He didn't argue. He just said, I'll be there. That same hour, the judge who'd presided over the original hearing sat in her office, staring at a blank notepad. She'd spent the night replaying every moment, the way he'd stood so still, the precision of his words, the lack of anger in his voice even when the system had failed him. She wasn't angry. She was unsettled, because part of her knew he was right. By midday, news vans lined the street outside the Bar Association's building. Reporters shouted questions as he walked in, but he kept his head down and said nothing. He wasn't there to perform. He was there to explain. Inside, 3 senior attorneys sat at a long table. One had been a prosecutor for 20 years. Another had taught ethics at a law school. The third had once defended civil rights activists during protests in the 90s. They weren't there to punish him. They were there to understand. Why didn't you file a formal complaint? The ethics professor asked. Because complaints disappear, he said simply. I've seen them. Filed by good people with solid evidence, buried under paperwork. Forgotten in 6 months, but deception in court? The prosecutor pressed. Even if your intentions were good, doesn't that undermine trust in the system? He leaned forward slightly. The system already lacks trust from the people it's supposed to serve. I didn't create that gap. I just stepped into it so others could see it. He pulled out a folder, not full of legal jargon but of faces. Photos, with permission, redacted letters, transcripts from hearings where kids were spoken over, rushed through, or dismissed with a wave of a hand. This isn't about me, he said. It's about them. The room grew quiet. Later that afternoon, the Bar Association released a statement. No disciplinary action would be taken, at least not yet. Instead, they announced a special review panel to examine juvenile court practices across the state, with input from public defenders, community advocates, and yes, even him. It wasn't a victory lap. It was a doorway. Meanwhile, the story kept spreading, not just online, but in courthouses, law schools, and community centers. A group of law students started a volunteer program to sit with young defendants before their hearings, just to explain what to expect. A retired judge wrote an op-ed calling for mandatory training on implicit bias for all court staff. Even the police department issued a memo reminding officers to verify identities carefully and treat every person with dignity, regardless of age or appearance. But not everyone was on board. Some lawyers called him reckless. You don't fix the system by playing games with it, one wrote in a legal blog. Others worried it would encourage copycats. People pretending to be things they weren't, muddying real cases with stunts. He read the criticism. Didn't delete it. Didn't argue back. He just saved it in a folder labeled feedback, because he knew this wasn't about being liked. It was about being heard. A week after the inquiry, he got an unexpected visitor, the judge from the original case. She didn't come in robes, just a coat and a paper cup of tea. They met in a quiet corner of the same park where he'd sat after walking out of court. "I've been thinking," she said, "about all the kids I've seen come through my courtroom. I told myself I was being efficient, fair, but maybe I was just being convenient." He didn't interrupt. Just listened. "I want to do better," she continued, "but I don't know where to start." He smiled faintly. "Start by asking one question before every hearing. Do you understand what's happening right now? And if they hesitate even for a second, slow down." She nodded slowly. "That's it?" Sometimes the smallest changes make the biggest difference. The next day she did exactly that. In her first juvenile case, a 15-year-old nodded quickly when asked if he understood the charges. But she paused. "Take your time," she said gently. "It's okay if you don't." The boy looked up, surprised. Then quietly, "I thought I was just supposed to say yes." That moment, small, human, real, was captured by a court observer. It wasn't broadcast on the news, but it was passed around among public defenders like a quiet promise. We can do this differently. Back at the Bar Association, the review panel held its first meeting. He wasn't there as a defendant or a disruptor. He was there as a consultant. They asked him to help design a pilot program, Youth Court Liaison, trained volunteers who'd sit with minors before hearings, explain their rights in plain language, and stay with them until the gavel fell. He agreed, but only if the liaisons included former defendants, not just law students. "The best teachers," he said, "are the ones who've lived it." As fall turned to winter, the first group of liaisons began training. They learned how to read a docket, how to spot when a kid is overwhelmed, how to quietly signal a judge if someone needs a break. Most importantly, they learned to listen, really listen, without judgment. One evening, he stood in the back of a training room, watching a young woman who'd once been sentenced to probation for a curfew violation, now teach others how to navigate the same system. She spoke with a calm strength that came from having been through it and survived. He didn't say anything, just watched, hands in his pockets, the same way he had weeks ago in that courtroom. Only now he wasn't alone. The system hadn't been overthrown. No laws had been rewritten overnight. But something had shifted, something deeper than policy. It was the quiet understanding that justice isn't just about rulings. It's about respect, about seeing someone fully, not just their file. And as he walked out into the cool evening air, he knew the real work was just beginning, not with headlines or courtroom drama, but with one kid, one hearing, one honest question at a time. Because change doesn't always roar. Sometimes it whispers, and sometimes it wears a hoodie. 6 months later, the courthouse looked the same. Same worn benches, same flickering lights, same quiet hum of routine. But something had changed. You could feel it in the way the bailiff greeted young defendants by name, in the way the clerk now handed out plain language rights cards before every juvenile hearing, in the way judges paused, just a beat longer to make sure someone really understood what was happening. None of it was written in stone. None of it came from a grand decree. It grew quietly like roots under pavement, slow, steady, and strong. He still came to court sometimes, but not as a spectacle. Not as a mystery, just as a lawyer doing his job. Only now when he walked in, people didn't stare. They nodded. Some even smiled. Not because he was famous, but because he'd shown them that caring wasn't weakness. It was part of the work. The state's pilot program, Youth Court Liaison, was running in 3 counties now. Former defendants, law students, and community volunteers sat with kids before hearings, not to give legal advice, but to offer something just as vital: presence. A calm voice. A reminder that they weren't alone. One afternoon, he watched from the back as a 14-year-old girl, hands trembling, sat beside a liaison who'd once been in her exact seat. The girl whispered something. The liaison leaned in, nodded, and gently handed her a glass of water. When the judge called her case, she stood up straighter. Not because she wasn't scared, but because someone had told her it was okay to be. After the hearing, dismissed with a warning and a referral to a tutoring program. The girl turned and hugged the liaison. No words, just gratitude, raw and real. He didn't film it, didn't post it. He just tucked the moment into his memory, right next to all the others that never made the news. The Bar Association never punished him. In fact, they invited him to help rewrite training materials for new attorneys handling juvenile cases. Focus on dignity, he told them, not just procedure. They listened. The judge who'd once scolded him in court now co-chaired a task force on procedural fairness. She'd even started a small fund to help low-income families afford transportation to court dates, because she'd learned that missing a hearing wasn't always about defiance. Sometimes it was about a broken-down bus or a sick sibling. He never sought credit. When reporters asked, he'd say, "This wasn't my idea. It belonged to every kid who ever sat in silence because they thought no one would listen." And maybe that was the real magic of it all. He hadn't come to tear the system down. He'd come to remind it of its own promise, that justice should be blind, not just to wealth or status, but to age, appearance, and assumption. One spring morning, he stood in front of a high school auditorium, not as a lawyer, but as a guest speaker. The students were restless at first, phones out, hoodies up, eyes half glazed. But then he asked a simple question. How many of you have ever been judged before someone really knew you? Hands rose, slowly at first, then more. Not because he was impressive, but because he sounded like someone who'd been there. I used to think the law was just rules in a book, he told them. But it's really about how we treat each other when no one's watching. And if you ever feel invisible, remember, your voice matters, even if it shakes, even if it's quiet. Afterward, a group of students stayed behind. One asked, "Could I really become a lawyer even if I've been in trouble before?" He looked him in the eye. "Especially if you've been in trouble, because you'll know what it feels like, and you'll fight harder to make it fair for others." That same week, the state legislature held its first hearing on juvenile justice reform in over a decade. The room was packed, not with lobbyists, but with parents, teachers, and teens who'd been through the system. He sat in the back, not to speak, but to bear witness. When a young woman stood up and described being sentenced without understanding a single word of the hearing, the room fell silent. Not out of pity, but out of recognition. This wasn't an anomaly. It was a pattern, and patterns can be changed. By summer, new guidelines were adopted statewide. Mandatory plain language explanations before any plea, automatic appointment of counsel in all juvenile cases, even for minor offenses, and training for court staff on trauma-informed communication. It wasn't perfect. It wouldn't fix everything overnight, but it was a start. A real one. He kept working. Not in headlines, but in hallways, in community meetings, in late-night calls with worried parents who'd heard his name and dared to hope. He took on pro bono cases not for the spotlight, but because someone had to. And sometimes, on quiet evenings, he'd walk past the law office where it all began, the one he'd stood outside of shouting into the dark. It was still there, but now a small sign hung by the door. Free legal 8 hours every Tuesday. He never went in. He didn't need to. The message had been delivered. Years from now, people might forget the details. The courtroom moment, the news clips, the debate over whether what he did was right or reckless. But they wouldn't forget the shift. The way a judge now looks a kid in the eye and says, "Take your time." The way a public defender sits down and asks, "What do you think we should do?" The way a scared teenager walks into a courtroom and feels, for the first time, like they belong there. That's the legacy, not fame, not victory, but trust rebuilt, one honest interaction at a time. He still wears hoodies sometimes, not as a disguise, but because they're comfortable. And when he walks into a courtroom now, no one assumes he's a defendant. But more importantly, no one assumes he's not someone worth listening to. Because the lesson wasn't just for the system. It was for all of us. Don't judge the book by the cover, especially when the cover is young, quiet, or wearing a hoodie, and somewhere, in a small-town courthouse or a city youth center, another kid is finding their voice, because someone once showed them it was okay to speak. That's how change really happens. Not with a bang, but with a question. Not with a disguise, but with truth. And not with one hero, but with ordinary people choosing every day to see each other clearly. He's still out there. Not as a legend. Just as a person who believed that justice should feel human, and had the courage to.